Thank you for staying with us. Let's get some understanding. Now, it's well known that international investment, law, and arbitration have been designed in a way to protect and promote FDI by offering the investor more often a multinational company a neutral forum to bring claims against the host state for breach of international investment treaty standards. Now, FDIs may impact the host state community, environment, and social context, and they affect that state's capacity to achieve sustainable development goals. Treaties usually do not contain provisions establishing any sustainability obligations as such upon investors. And investors are usually not involved in investment treaty-led or investment treaty-based arbitration as respondents. So counterclaims by states have been rare due to the limited jurisdiction of treaty-based arbitration and the lack of instruments to make investors accountable for their wrongdoings. And there are those who believe that that has also contributed to the backlash against international investment law and the investor-state dispute settlement, that is the ISDS mechanism, which have been accused of primarily benefiting the investor to the detriment of the state. Unfortunately, in most cases, it's the investor against a developing state. And developing states, the state in this context is usually about countries. Let's have conversations this morning with three gentlemen, all lawyers, by the way. Dr. Olabisi Akinkugbe is Associate Professor, Purdy Crawford Chair in Business Law, and from the Dalhousie University, Canada, and founding editor, Afronomicslaw.org. Thank you for joining us this morning, Dr. Akinkugbe. We also have with us Professor Demola Abbas, who is a professor of international law. He is a former special advisor to the Lagos State Governor on overseas affairs and investments. So you could say round peg, round hole. Thank you for joining us this morning.
Thanks for having me.
Let's begin with you, gentlemen. I understand Dr. Gbenga Ade has also joined us. He's a lawyer and chartered accountant, international business law expert as well. Thank you for joining us, Dr. Ade.
Thank you. It's a pleasure to be here today again.
Great. So let's begin with you, Dr. Akinkugbe. From all of the things that you know, the case in point, which has brought us this conversation so far, is that of the case between the Chinese company and Ogun State. What do you think is missing? What is wrong? What's going on?
Thank you very much. That's a good question. I think the place to start is to understand that there was a drive for investment by foreign investors. It is not uncommon for governments like ours to seek to woo investors in various forms. In this particular case, this was through a special economic zone. There was investment purported, investment in there by this Chinese firm called Zhongcheng Fengchang, to be short. And so it was in the process of carrying out their supposed investment that they have alleged certain wrongs by this sub-state, Ogun State, some agencies of the federal government of Nigeria. But at the heart of that is the bilateral investment treaty that was concluded between Nigeria as a state and China. As you have rightly said, these type of treaties, it's not uncommon for parties who sign them to insert in them an arbitration clause. And most times it's about triggering a particular system of disputes that is called investor-state dispute settlement. Now, one might wonder, why is it that a state government supposedly driven investment has landed Nigeria in this kind of dispute? Well, it is because this is supposedly, or one can argue, an action that can be attributed to an agency or that is deemed to be part of an activity that the Nigerian state can be said to have undertaken. And so the investor in this state has, in this case, has triggered that particular investment arbitration and has taken Nigeria to the arbitration dispute settlement, and they won. And so it is out of trying to get the benefits of their dispute, which is in the rough figure about $70 million US plus whatever the interest is today, that has brought us this far.
Well, let me ask you also, Dr. Adeoye, from what we know, this case is, there are those who believe that it is similar to the PNID case in a way or the other. Now, our conversation this morning is not particularly making a specific case of the Zhang Cheng case that, we are talking about, as Dr. Akinkugbe rightly highlighted. But there are those who say that, it's just some international investors trying to fleece the nation in some way or the other. Just as in the PNID case, which even though they won several cases back to back, in the PNID case, Nigeria eventually, won the case. So do you see any similarity here? Dr. Adeoye, that's for you, sir.
Yes, it's similar. Yes, it's similar to an extent. But it's important to note that 7 sections of Company and Allied Matters Act is devoted to foreign company participation. And so it's not out of place for investors to come into your country. There are 2 major reasons why people can come into a country. Number 1 is because of technical know-how, and number 2 is capital. And so as an investor, every capitalist wants to make sure that his investment is protected, and you don't want sudden breach of contract along the line. But also, we have a responsibility to ensure that every line in any agreement is looked into critically so that you don't shoot yourself in the leg. We understand that some foreign entities come into Nigeria basically to ensure that you breach the agreement so they can make claim, like you have in the P and ID case. So, but by and large, there is nothing wrong in having foreign investors in your country. It is important to note that there is no country that is totally self-sufficient. It is either you are buying raw material from a country or you are buying finished goods. It could also be that you are exporting raw material or finished goods. But what most countries try to do is to ensure that they engage in the value chain of every raw materials in their country. But technical know-how is one major factor that makes countries or states to call for investors into the country.
Let me ask you, Prof. There has to be some background to this particular case. The timeline we're aware of is that the whole conversation started in the year 2001. That's just 3 years into the Fourth Republic. You may also remember just 1 or 2 years into the Fourth Republic. You may also remember that was about the same time the president went all over the world clamoring for foreign direct investments into the country, and perhaps that's what informed China and Nigeria signing that bilateral investment treaty to encourage investment between the two countries. And of course, the foreign countries came, and one of which is this Zhongshan Fujian Industrial Investment Company. So given this and a number of other things that maybe, what's the background that Nigerians need to know from your experience or from what you know about this particular case until we got to this point?
Thank you very much, Ayo, and nice to see you again. Well, I think that is a very important question you asked, because sometimes when things like this happen, there's a lot of emotions involved. Number one, as nationals, Nigerians are quite rightly, we are upset that a foreign country has seized our assets. So we understand the human emotions. However, whereas humans can be emotive about this, a country cannot afford to be emotive. And that is because there are serious legal issues here. Our country, will still be dealing with other countries. You rightly said, 2001, Nigeria and China signed the BIT, Bilateral Investment Treaty, which is to promote commercial interaction between the two countries. But more importantly, for each signatory to that treaty to be able to protect investors in each other's country. That is very important. It's important because that is what is an issue. And anybody who has taken time to read the judgment of the Court of Appeal, Columbia District, which we are dealing with August 9, 63 pages, will know that is the core of the matter. Let me first of all clarify something before I even came there. I get to that, the timeline. There is a wrong notion that it is between China and Ogun State. No. Ogun State, obvious, as I said, 2001, there was a treaty between Nigeria and China. 2007, Ogun State, in furtherance of that treaty, then decided to conclude, to instigate a commercial relationship with Chinese companies to be able to set up a free trade zone in Ogun State here. 2010, then Ogun State again contracted Zhongshan company to develop industrial park within that particular trade zone itself, which was done in 2010. And, there was a lot of activities, and Ogun State made almost 160 million naira, or Nigeria 50 million naira from tax generated during that particular time. Let's keep that in mind. 2016, Ogun State then terminated the agreement between it and that particular entity, the Zhongshan entity. Now, I'll clarify again. Any contractual party, any party to a contract has its right in international law or in domestic law to terminate a contract, provided that you do it in accordance with the regulation between you and the other party. And if you don't, then you have to be able to face the consequences. When that happened, of course, the other party, the Zhongshan party, was quite upset. In record, they then thought that they were being, gone after by Ogun State, by Nigerian authorities and this and that. Then they went to Nigerian court. Don't forget, they filed a suit in 2018 in both federal and state court in Nigeria. That's if not 2018, the suits were continued. The first time they tried to bring an arbitration was about 2019 in Singapore. They didn't go through. Then they went to the UK and they filed an arbitration in the UK. That took place in 2021. United Kingdom awarded them about $55 million. And on record, they claimed Nigeria did not pay, which then made them to go in 2021 to the district court, which is like a high court in Colombia and the United States, to be able to bring that. Now, the question then in terms of time, what encouraged them to do that? You will remember very well that by 1976, the U.S. Congress had adopted the Foreign Sovereign Immunity Act, FSIA. And that act is basically to allow United States Court to recognize and to be able to enforce arbitral awards granted overseas. So the award in question here was the award granted to Zhongshan by a UK court to be enforced in the United States. That was until 2022. And the first reaction of Nigeria was that the District Court of Columbia did not have jurisdiction over the case. Of course, the court affirmed its jurisdiction. I don't want to go into details of why they did that. And Nigeria then promptly appealed to the Court of Appeal. That decision was given last week, which is August the 9th. And it was that decision that then the court said, okay, China can go after the assets of Nigeria into the seizure of our 3 aircraft in France. That is the timeline, 2001 and 2024. I haven't gone into the meat of the, I think we're still going to go into the meat of the matter it needs to be. Because one of the reasons that Nigerians have been upset of where we are getting from Trump is whether a foreign country can impede another country or can seize our asset, which seems to be a violation of our sovereign immunity. That is not going to be the case. But I hope we are going to get there. But that is the timeline you have asked. So that is how things have panned out. So number one, It is not between Ogun State. It's not between Ogun State and China. No, actually, because the treaty we are talking about is between Nigeria and China. Ogun State only happens to be an entity that is, involved there because they were the one that did the contract, but it's Nigeria that is actually involved here. So we come to
Dr. Akinkugbe, the presidency has spoken, and the presidency was reacting to an action taken by a Chinese company. And the position of the presidency is that the Chinese company is trying to reap more than it sowed, or whichever way we want to look at it, depending on the side of the elephant you're looking at. Do you see any justification in the claims being made by the Chinese company?
Thank you very much. So I think before I come to the more pinpointed answer to that question, it's important to contextualize it. That the dispute settlement regime that we're talking about today, that's the ISDS, is not one that is necessarily celebrated around the world. A private sector practitioner might as well say, it brings me a lot of income that I have to do this work, so I do not care. But there's a fallacy out there that if you have investors coming to your country, it almost always generates some kind of economic growth or economic development. There's in fact no real empirical evidence to back that up in the case of investor-state agreements or investment agreements. The generality out there in terms of empirical evidence is that these agreements oftentimes actually end up creating more challenges in terms of environmental situations, in terms of a crisis like we are going through now. And so there's a whole lot of scholarship in there that shows that investor-state dispute settlement, particularly this type of arbitrations, are systemically generated against the interests of developing countries. Why is that so? One can think about, number one, the exorbitant nature of damages that are often given. We have referenced P and ID today. The second way we think about it is that they also actually limit the policy space that governments have to take actions that are necessary for their government, for their development. As such, it is not unusual for investors to trigger this type of disputes on the ground that certain kind of provision, the general clause, which is called fair and equitable treatment provisions, has been breached. This particular type of provision gives them a significant leeway to make different types of arguments that really, almost always finds the host state in breach of the agreement.
But is that out of place? Just a second. Is that out of place, really? Because in most cases, you find out that the state, whichever country it is, always has more power than a company.
It is indeed out of place, but this is the regime we're talking about. It is the system. And what we're talking about is a systemic inequality. It is the fact that when this type of regime started many years ago, a lot of our states were still under colonial rulership.
I'm not even talking about Nigeria in this case, Dr. Akinkugbe. I'm talking generally. I mean, and I'm almost certain that this provision you're talking about is not only restricted to Nigeria or affects just Nigeria, definitely affects other countries as well. So it begs the question whether or not indeed, it is out of place simply because on a good day, one policy from a government can knock off any benefit that will come to any company from any part of the world. So that's the basis of the question I'm asking.
Well, the basis of it is you can say, the policy can knock off, but this is an agreement, right? I mean, contractually, we do talk about sanctity of contracts. And everybody would need to say, once you've signed it, you should work on it. But the premise for signing any type of investment agreement, bilateral investment treaties, is that governments will not take actions that will frustrate the investment of the investor, that will frustrate them from recuperating their capital and profits that come from it. So it's not unusual, but the point I'm trying to make which is to answer your question more directly, is that this particular kind of practice is seen everywhere in the world. In fact, to draw a very interesting example, Honduras right now is currently fighting an $11 billion case against an investment, right, that is made in a special economic zone, similar to ours, against a U.S. investor called Prospera, right? The past 3 years has seen a series of cases in Europe on the account that the government took measure to regulate their environment for more enhanceable climate-friendly situations. And so there were 3 cases that at least went to arbitration. So the point is, all over the world, there is a division, both amongst scholars mainly, maybe less so amongst practitioners of law, about this particular regime that has triggered the case for its reform. And the case for its reform sits on 2 types of legs. One, there is the case for the procedural reform of the investor-state dispute settlement. There is the case for the substantive reform of the investor-state dispute settlement. The procedural reform really looks at issues that come out of, for example, an arbitrator who already represented a party, subsequently sitting as an arbitrator on a panel subsequently. You call that double hatting in the technical sense. There are other issues in terms of updating the rules that regulate arbitration that has been attended to, but that's not where most countries have issues. Most countries have issues in relation to the inequality that is embedded in this regime. The idea that an investor can sue a state and the state is left only at the mercy of counterclaims. That really is the heart of the problem that academics have pointed out at investor-state dispute settlement and its overall investor-state agreement, that it is very asymmetrical and does not carry on or concern the interests of the investor-state. I'll give an example and then I'll pass it on. If you think about the fact that a state like Nigeria or Honduras, right, have significant debt profile. At the top of this interview, we mentioned our ideal to, achieve sustainable development goals. Well, you know what? The capacity of a Nigerian state, of Honduras as a state, to achieve its other economic development goals or climate-oriented actions is significantly undermined. If, in addition to, for example, servicing its debts, which is very high, it's having to bleed through this kind of awards to investors. And in some cases, the investments hardly ever do anything. And so the last thing I'll put on that is the calculation, the quantum of damages. Academics have asked questions about that. One might look at this one and say, Professor Abbas did mention the actual amount that was given. When I said 70 million, is if you think about the additional cost of defending the action and minor damages that were given, that takes it up to 70 million. Okay. But the truth is also that is also an issue generally. But I'll leave it here and we can come back to that.
Thank you, Dr. Akinkugbe. Dr. Ade, I don't know if you have looked at the case, the judgment and all of it. Now, you mentioned the PNID case the other time, which started itself like this one. That one actually was between Nigeria and a different company, all together. Now, if we're to look at the value or merits of both cases, and as you said, PNID got judgments all, up until a particular time that the federal government, got a judgment in its own favor. Meanwhile, there were Nigerians who were saying, look, let's settle this PNID case once and for all. Let's pay whatever we needed to pay and all of that. So there are those who said that there were some collusions in that particular case, the PNID case, between Nigeria and some Nigerians and, on the side of those other organizations. Do you see a similar thing in this case? Because there are those who are already alleging that maybe there are some Nigerians who are also, trying to make some money off of this case against Nigeria.
Well, I can't say that categorically at this point in time, but the caution I need to give to state government is to make use of professionals in every agreement. Now, when you are terminating a contract, everybody knows, I mean, lawyers are on this panel, all of us, almost all of us are lawyers here. When you are terminating contract, you must bear in mind that there are consequences. And so what you look for is the window where you are able to prove that the other party has breached a fundamental element of the contract. And if you have that in place, you don't allow the other party to hit you below the belt. And just like we take court processes in Nigeria, where government normally think that, well, this is an entity that is not an individual that you can physically imprison or do anything to, we take into
Well, I'm pretty sure that we'll get Dr. Adeoye back on that particular case issue that we're talking about.
That was a break in communication there.
Yes, I noticed.
When I was talking.
Yes, go ahead.
What I'm saying is that the government, the responsibility still lies on the government. Now, when you look at state government, international community do not recognize state because most of the contract has a sovereign guarantee embedded therein. And so taking over our presidential jet is a very good option. I hope you are aware that this is not the only asset these guys are laying hands on. I think they've taken our house at Liverpool also, in which case they come up to say this is the value of the property. So my concern is, where are the lawyers working for the state government at the Ministry of Justice? Forget about the decision of any governor either to sign or to cancel contract. We have professionals, lawyers, who are supposed to look at the various elements of every contract. Even you at channels as an individual, if you have contract to put your transmission equipment somewhere, or you have your building somewhere, and then your landlord suddenly want to terminate the contract, you will actually exploit legal means to ensure that you are compensated. But again, I feel that it is our duty as a government to ensure that whenever somebody has breached fundamental terms of the contract, we take action faster than them, and where they have taken action against us, we put people who are knowledgeable about the contract. But let me tell you, the major challenge that I found in my country is that, lawyers will tell you clauses that will put you in bondage in every contract. They are very tiny. They don't appear at the early part of contract. The clauses are hidden somewhere, and you see clauses that are negating other clauses that are earlier. And so at the point of reading the contract, every line item should be studied. But because we're looking for money, sometimes we forget that you may get the investment and you will lose times 10 of what is in your country. So again, terminating contract is something we need to exercise caution about, because it's a friendly relationship that is supposed to be, because Nigeria has bilateral treaty with China. So I wouldn't say that there are people who play the role that some guys play in the P and ID case, but I would say sometimes it is negligence on the part of professionals who ought to study properly and advise the political office holders and say, if we do this, these are the implications.
Well, while there is value and credit in the position that you have taken, Dr. Adeoye, The reason for the question is not far-fetched. For instance, how did this company, not even the country, how did this company know that Nigeria had assets such as aircrafts in certain specific places in the world? That they went to those places to ask for them. That's the basis of the question, really. But let me.
No. I don't think there are issues with that. Every aircraft has a number. Every vessel, every ship, wherever you are in the world, they can track you. Whether you've gone for repairs or you are in the middle of the sea. If we had vessel, they could seize our vessel. They could seize anything. This is applicable in international law.
Okay. Dr. beg your pardon, Professor Abbas. Now, what is it that Nigerians need to know about this judgment? We know it started some time ago, I think about 2016, 2018 or thereabout. But what is it that Nigerians need to know about the judgment? Because I'm not sure everyone, 200 million Nigerians have read it. Yet we're all feeling that this is a huge, avoidable embarrassment.
Well, thank you very much, Ayo. And I think I like the last part of your sentence, that is a huge, avoidable embarrassment. I will add international to it. But let me clarify certain things. Look, first, whenever we have cases like this, for goodness sake, let's try, as very decent people in Nigeria, let's try not to quickly assume that somebody is just trying to fleece us or there is a fraud somewhere along the line and this and that. I say that because sometimes it's just like, little baby crying. Sometimes we leave undone that which we ought to have done. Let me give you a simple example. Nigeria didn't even need to be involved in this case at all. If Nigeria had not agreed to the arbitration clause in the first place, you don't have to agree to arbitration. And the court in the United States made it clear on that judgment that you are talking to, and I read the whole judgment, 63 pages. You go to pages 18 and pages 22. Judge Miller in judgment made it very clear that Nigeria didn't even need to agree to the arbitration at all. The moment Nigeria agreed to the arbitration, made itself part of that, having signed the treaty on behalf of the country itself, then you made yourself part of that. So, of course, they wouldn't go after Ogun State. They would go after the country because the country is a part of the one that signed that particular treaty. So let us stop looking for a needle sometimes in a haystack. Don't get me wrong. I'm not saying in PID or in other cases there will be no. I'm not saying there might not be in some cases there will be no basis for suspecting fraud and this and that, but not in every case. In this particular case, it's going to be very, very hard to do because we have left undone completely so many things. I'll give you another example. The basic issue in this particular case is the FSIA, that is the Foreign Sovereign Immunity Act, concluded obviously in New York in 1976. Nigeria acceded to that, didn't sign it, but acceded to it, agreed to be, for the arbitration to continue. So you cannot approbate and reprobate in law at the same time. So we have accepted that particular responsibility. We're going to be part of it. Now, so Nigerians need to know, number one, we have a lot of unforced error. Cast your mind back to Bakassi case as an example. Again, we were very upset and so many things and this and that, but we forgot. I will tell you something. Let me give an anecdote. I was a postgraduate student in Cambridge in 1997 when I walked up to Professor James Crawford of blessed memory now, who was my professor there, and I asked him a simple question. He was leading a Nigerian case in Bakassi, in the ICJ, then General Court of Justice. And I said, sir, what are the chances of my country winning this case? And Professor Crawford looked at me straight in the eye and said, Nigeria will lose the case, but as lawyers, we have to try our best for it. And I said, on what basis? Now, remember, one of the plank arguments of Nigeria and Bakassi was that the agreement, Makusa agreement, signed by Gowon, that Gowon signed the agreement without the concurrence or the approval of the Supreme Military Council, SMC then. You don't make that argument in international law. Gowon was the head of Nigeria, head of state of the country. So whatever the internal irregularities that attended the act of a head of state or a minister representing the country cannot be imputed to a foreign country, because a foreign country doing business with you will not be asking, oh, did your minister comply with your internal regulation before they come and sign the treaty, or did your head of state comply before they come and sign? No. The head of state, any top official of Nigeria who had that competence will be taken to have the competence to be able to do that. So we need to avoid a lot of unforced errors. There are too many unforced errors. And I think I agree partly with what the last speaker said. I think Dr. Lee said. Yeah. Dr. Lee said. We need to be very, very careful, when we sign that agreement. I think what I've seen so far, again, this is not casting aspersion. Nigeria seems to continue to make a particular mistake in which whenever we have cases of purely international law matters, we send in professors of contract. There is a remarkable difference between contracts within domestic law and contracts at international law. They're very, very good. In international, you're dealing with, as a clear example is, for instance, a very seasoned international lawyer will have put a single case up in the US court. What about espousal right? It was actually brought on by the dissenting judge, Judge Castas. In this point, there were 3 judges, Millet, Castas, and the other judge. Judge Castas was dissenting, and he made a point that what about the espousal right? Now, what does the espousal say? If there is a contract between a country and an individual, the individual cannot sue the country. What that individual will do will be to go to his own country, our own country, for the country to espouse that individual's right before the court. So in this case, the Chinese company will have gone back to the country, China, and asked China to protect or to vindicate its right against Nigeria. That is called espousal right. Of course, the other judges rejected that you didn't apply in this particular case. But we didn't even make that particular argument. In international law, we call it mad romantic case. We have a lot of international jurisprudence cases on such things, but we don't do that because we put our wrong foot forward. We keep sending professors of contract law on seriously international legal matters. That is what Nigerians need to know. And that's why I say I agree partly with what Dr. Adewale said. That's very important. So let's stop suspecting fraud in every single international case. And coming back to what you said earlier, I ran investment for Lagos State government. Every investor who wants to put $1 in your country wants to be sure if there's a crisis, their dollar is protected. Now, every investment that comes to your country, be investment in your country, wouldn't necessarily agree that it is only the law of your country that should grant investment, because the law of the country can work for you. After all, it's in that country. So imagine if I come and invest money in Nigeria from, let's say, Antigua or wherever, and then I'm saying if there's a crisis between me and Nigerian government, it's Nigerian government that will apply. Or Nigeria saying it's Antigua government. No, what those parties will do, 2 of you will do, is to build a compromise, we call it international law, that a third state arbitration will apply. In this case, that was what happened. So there's nothing wrong in that. However, a country does not need to agree to a particular arbitration. If Nigeria did not agree to it, we wouldn't have been pleaded in this particular case at all. They will have gone to court, we will have alleged lack of jurisdiction, and the case will have died there, and they could have settled out of court. So again, let us be mindful of that. But see, by and large, I think there are many lessons for Nigeria as a country to learn from this. Number 1, as I said, let's be very, very careful before we jump onto arbitration clause. Number 2, there should be a greater cohesion between our states authorities and the federal government authorities. As I said earlier on, the case is not between Ogun State and the Chinese company. No, Ogun State was not implicated in the court, and Ogun State could be within its right for terminating the contract. You and I don't even know the fact of the contract. You have to read the case itself. Even at the Court of Appeal in the UK, the District of Columbia, they didn't go into the meat of the matter, because what was in issue was whether the initial court the Chinese company went for, that is the district court, whether it had jurisdiction or not. Which confirmed jurisdiction, then Nigeria appealed to the Court of Appeal in Colombia, which again confirmed. So they were only dealing with jurisdictional issue, and they went into the issue of sovereign immunity, which I don't think we're going to have time to actually go into that too. So that is the substance is not the issue. So unless you and I know what actually transpired between the Ogun State and that company, we cannot effectively comment on it. The only reason I know that is because I read the whole judgment in the UK in the arbitral award, and I also read the whole judgment that was given in the US. So I know the fact, but the fact I know the issue here. But what we are talking about is the processes that we lend ourselves to. So it's very, very important.
Well, there's something, there's something Dr. Akikugbe said earlier, Prof, and I'd like you to quickly speak to before I go back to him, because I know he's also raring to respond to some of the issues that you've raised. And that's the fact that it would seem like the international investors usually get the upper hand, so to speak, in the arbitration matters, even in the laws, the ISDS that you all have referred to. It would seem like it always favors more the investor as opposed to the host country. And unfortunately, in most cases, it would seem like the developing countries suffer more in that regard. We are not all unaware of, I'm not sure whether it's Zimbabwe or Zambia, where Chinese companies were said to want to take over certain infrastructure of the country. Even some even say, well, they want to take over certain social services or even security apparatus of the country. So, is there any way to adjust that, Prof?
Thank you very much for that. You know what I always say in this kind of situation is that if your sport is riding on the back of a tiger, then don't cry wolf if you end up in the belly of the tiger when it's hungry. More often than not, the first time we actually respond to this kind of thing is when these agreements break down. You and I never actually care to know what terms did this country agree to. And I'm not talking only about Nigeria here. I'm talking about other countries. Look, I know many countries in Africa here that experienced conflict. After conflict, they were rearing. They were hard pressed for money, and they were willing to do any deal whatsoever to be able to get foreign currencies. So China went to some countries in West Africa, yes, Sierra Leone and co, including in Central Africa like DRC and East Africa, and they were able to do silly deals in which countries box them, some of them up to 25, 50 years of mining rights to certain countries, including China. Now, when they default, and then these entities now go after the property, then we cry wolf. So it's important for us to take a step back and be very careful in the kind of agreement we agree to.
Well, Prof, my apologies. Thank you, Prof. Dr. Akinkugbe, I know you want to respond to that as well, but here is the angle that I'd like you to look at. I just went on the website of the Lekki Free Trade Zone, and I'm seeing that indeed there are quite a number of companies who are not of Nigerian descent in that are listed as investors at the Lekki Free Trade Zone. So it's not, in other words, I'm saying it's not that it cannot be done. It has been done. It is being done. Are there lessons to learn, particularly for other states in that regard, such that we don't have this kind of embarrassing, as some people have put it, avoidable and embarrassing situations?
Thank you very much again, Aya. So I think I'll go straight to this question. I think the idea is not to demonize special economic zones or free trade areas. No, I think they have their purpose. As you have rightly said, there are other corporations within this particular economic zone that are still working. The point, though, is one that has been made in different forms in the course of conversations on this panel, and it is that there is an obligation on a state or a country that has invited investors into its countries to make sure that it is standing very well on its legal, economic, and political standings very well. In this case, you can think about what is the legal sense. You have to think about the fact that if you're making, as an example, any laws or new law that may impact investment, that you are properly advised. And Dr. Adeoye mentioned it. Having a lawyer that is skilled or a team of lawyers that are skilled at their work is not about having them only at the time of drafting the contract. If there has been turnover in the office or in the Department of Justice, or the firm that you acquired, that you briefed, is no longer working on that, it will fall through the cracks. It means the National Assembly or the State Assembly or the Federal Legislature will pass a law that may impact, right, that particular investment, for which the investor may then say, there is a law that has here impacted our investment. It's also about political action in the change of government. Governments have to advise themselves very well, and I mean governance, executive persons who have been elected into offices who might think that there are actions that need to be taken to, make the state much more economically viable for one reason or the other. When they are taking those political actions, it can actually also be the basis of an investor action if it impacts the action of the investor negatively. So, there is a portion of this that one has to understand at the national level that runs through various areas. And these provisions are common in every BIT. Look, BITs are hard to negotiate out of, I have to say. I'm now segueing back to Professor Abbas's point. I think the idea that a state like Nigeria, who is seeking investor or any other sub-state, can say, I don't want the ISDS provision, is not really and looking at it with the context within which a state like Nigeria wants it. Every government that comes in promises foreign investment. They will go on these dance shows around countries and they will tell us we have secured this amount that is coming in. Of course, the investor will want to be protected. So, particularly, bilateral investment treaties are a species of agreements that have existed in their own for so many years, and 90% of this type of agreements that's in existence today are skewed against many developing countries. And developed countries are realizing that today as well. Now, if one talks about newer investment agreements, about 10% of them are in existence. They are not necessarily the basis of any kind of dispute, but the reason they are new is because they attend to sustainable development crisis, climate change issues, environmental regulation, and so on and so forth, which states want to be able to do to make sure that they are acting in consonance with their obligations in other international agreements, like, for example, the Paris Agreement. So to come back to the question, I think there is a nuanced way in which Professor Abbas's point can be presented differently, in the sense that the international law dimension of this in relation to the foreign enforcement dimension, which is happening in New York, is critical. And there's no reason for Nigeria not to make sure that it is effectively defending that, right, and availing itself of all forms of international law defenses. But the basis of that particular enforcement that is sought is actually the breach of a contract, right? Investor-state contract. And at the heart of investor-state contract agreements or investment agreements is contract and property law. So I think they all overlap. And there's something that we're all saying in here, that number one, at the level of drafting the agreements, it is critical for the government to ensure that they put their best foot forward. I worked in a project that brought forth arguably Lekki Concession Company, right? But the drafting of those kind of agreements, as Lagos State has done in many of its own agreements, tries to engage with the best legal minds available that are skilled in that area. Number two, that we have signed an agreement is not the end of it. Contract administration is critical. We do have to have people who monitor the terms on which the agreements are being performed, and to ensure that they are being performed to the letter to protect Nigeria as a state, but to also hold the investor accountable to their own obligations, such as environmental protection. And number three, that when, as Dr. Adeoye has said, we perceive that there is some kind of violation of this agreement, we do not sleep on our rights. Likewise, when we have been taken to court, we don't wait till the last minute to then try to put our house in order to appear in court. So I think, there are issues we can look at that tries to address the way Nigeria has defended. But I think there are much more deep issues that we have to address about the nature of the beast we are dealing with. The investor-state dispute settlement regime is not unique to Nigeria. Developing states across the world are pushing against it. Senator Warren has a letter that if you just Google online right now, is there about 6 pages to the US Senate telling them this particular regime should no longer be there. The United States, Mexico, Canada recent agreement that has just been completed has phased out ISDS between some of the states, and there are steps being taken to make sure this doesn't come back. So we might say we are doing our best. On the one hand, to try to say certain actions are being taken to negotiate properly to ensure we have terms that are in those agreements. But an investor that is coming in with $1 billion may not want to subject themselves to Nigerian government, to Nigerian court, as Professor Abbas has said. They choose the laws of another country. And so in that sense, we have to start thinking about how we do things differently. There are other investment ways that we can, as a state, put our foot down as the way to go, other than pushing ourselves down this treacherous SDS regime.
Very interesting, Dr. Akekugbe. So let me go to you, Dr. Adeoye. This happened between Ogun State and a company in China. Now, what's interesting here is that the case wasn't championed by China, even though the bilateral agreement is between Nigeria and China. Well, I'm just trying to help some people understand how it is that the organization, the company, didn't go for the investment of Ogun State in other parts of the world. They went for Nigeria's investments, assets. It wasn't even the Chinese government that was taking that step on behalf of that company, even though it was on the basis of that bilateral agreement that that company came into Nigeria to do business. So help us understand that basis.
Okay. You've heard about Lekki Free Zone. What you have in Ogun State is a zone that is created by law, NEPSA, Nigeria Export Processing Zone Authority. And so that is not within the purview of any state. Free zones are creations of laws. And if you look at what Obasanjo did during his regime, the essence of free zone is to bring investors into the country and then make them feel comfortable that they are outside custom territory. So what free zone does is to say that every company that is existing in the free zone, they are more or less in their country, untouchable, exempted from all taxes, and it is because we want production in the country. Now, when you look at after the cancellation of the agreement, you have a right under international law to ventilate your anger through an arbitral process, which is already in the contract. Now, for every contract you enter into in a country, the laws of your country, that is Nigeria now, the country has a status that is recognized under international law. And so if you are seizing asset, you are better off to go after what belongs to that country. By virtue of that agreement between the Chinese company and Ogun State, by inference, an agreement has existed between, or a right has existed between that company and the Nigerian authority. And so you will realize that if we probe further into this matter, the processes have been long, ongoing. And so I want to believe that we could have done better than we have done. This matter ought not to get to this level. It is like a student entering university. You must, when you are entering the university, because the university has the skill to give to you, the knowledge, the hostel, and the classroom, you must comply with the regulation of the university. So in this case, don't let anybody deceive us. Everybody that is receiving money, you stretch forth your hand, the person giving you money says, no, I want to put it in the middle of your palm, or I want to put in one palm now, or bring your pocket, I want to put it. This is how investment is done. Whoever is bringing out money, usually there's no way you think about it. The terms will favor you. Just go and check every offer letter from banks. When you want to take loans, they're going to put certain things. Interest rate is this. Repayment is 18 months. If there is a change in the basis point by the central bank, this is what you're going to do. So let's not blame international investors. You want to protect yourself because you are putting down your money and you don't want to be caught unaware. And if you don't go to a third state, court system, you are going to run into trouble, because we believe that if we go to your country will want to favor you. If we do it in Nigeria, of course, the whole thing will be scuttled. And so that was what led to the issue of having to go to UK and then now the US. So for every investor, you want to protect yourself. So I do not blame any organization exploring options to get redress. But my problem is that because of the bilateral treaty between Nigeria and China, if you have any problem with any Chinese company you don't even have to go through the court. Immediately, the Chinese ambassador, they are there. You sit down, you look at it. What are the fundamental terms that have been breached? What is the focus? The question to then ask is, what happened to Guangdong Free Zone in Igbesa? Don't forget, this is my state. Ogun State is my state. So I'm concerned about that state. So it could also be that there are, actions that you ought to take as a state receiving investment to complement what the investor is doing. So if you fail to do that, then they will also have a reason to breach certain fundamental terms. So in all of this, I think we should just get serious as a country. We should not be lackadaisical at the state level, and we should not take other parties for granted. And of course, when you have a foreigner that has brought money to your country, you must be watching them, because nobody, the Yoruba says, everybody, they want to, put everything to favor them. So I believe that we ought not to have gotten to this level. And even when you went to arbitration, there was an arbitral award. What did you do? You can sit down and then negotiate and discuss. Okay. So, in my view, government has a role to play, but at the same time, how did you monitor them over time in that place so that you put it at their doorstep that they are the one breaching the agreement? In that case, you are the one having the claim.
Okay. Well, Dr. Ade, you raised an important issue, and I'd like to ask Prof about that one, Professor Bass. He asked the question whether or not there was an interface between the Ogun State government, this Zhongshan company, as well as the Chinese embassy or government in Nigeria. Do you think that could have staved off this embarrassment?
Well, yeah. Look, there's no reason why you cannot conduct arbitration simultaneously with other political avenues to resolve international disputes. Diplomacy can be conducted on different levels. So there's no reason not to do that. But however, I think one thing we have to keep in mind, and I think I've said that a couple of times now, the case is not between Ogun State and the Chinese government, no, or the Chinese company, no. The contract is between them. What was the issue in the court was between Nigeria as a signatory to the BIT and China. The obligation of Nigeria is towards those Chinese companies that came to invest in Nigeria. So what the company back to your question, why they didn't sue Ogun State, is that you can only sue Ogun State for a breach of the contract, you get damages, which is minimal. That is not the problem of the Chinese company. The Chinese company is saying Nigeria has failed its responsibility, the duty it owes them. Now,
just a second, Prof. The reason I asked that question is just to stave off the situation that we have on our hands now, right? Because other states are already going around. I think was it last year or even earlier this year? About 8 or 9 states visited the AFDB headquarters in Abidjan, and naturally are having conversations around investments, the Special Agro-Industrial Processing Zones project, which Nigeria is also the one that is going to guarantee. Yes. So states keep going out like that. But when these things happen, it's to the country that all of these issues arise. So that I'm just asking, I'm not saying that it's between Nigeria and China. I'm saying it is between this Chinese company and Ogun State. But as you know, if it's a splatter that once you hit it, it's really splats on the country. And that is what I'm just asking, maybe an intervention between the Chinese government and that company with the Ogun State government, perhaps maybe anyone else, could have staved off this embarrassments of a judgment against Nigeria.
Yeah, actually, I was answering that question by saying you can conduct diplomacy on different levels. What I'm saying is that the fact that it is between state and Nigeria, if Ogun State government goes to Chinese embassy, wants to see their ambassador, does not still stop China or that company from vindicating their right under that particular treaty. You have an arbitration clause. Because now, why would I want to sit down with your ambassador and agree with you when I know that I'm not going to get what I really want to get from the case? Don't forget, a company that comes to your country has made a lot of investments. Sometimes hundreds of millions of dollars or sometimes billions of dollars. So why I am not going to puncture your face? Why I'm not going to say, oh, I'm just going to go litigious on you? Why I'm not going to close any other avenue for political resolution? I'm not also going to forgo my right to make sure that whatever damages, whatever injury I've suffered are properly redressed under international legal norm. That's what I'm talking about here. So we cannot simply say, oh, we're doing this and that, or Ogun State should have gone to, I should have sat down with a Chinese company or China as a country and this and that. Ogun State is subnational. And as a subnational, you may not actually want to go and sit with the Chinese ambassador. That is why you have to go under the aegis of your country.
That's actually quite dramatic when at any time the ambassadors of these countries go to visit state governors. But, that's another conversation altogether, Prof. Dr. Akikugbe, let's begin the round off now. 1 minute each, gentlemen. So where do we go from here? Nigeria, well, it's a $70-something million business. In other words, Nigeria owes that money. Otherwise, our aircraft wouldn't have been impounded or seized, as has been said. Who pays this money? Where do we go from here?
Well, in terms of who pays the money, I'm not able to say that, but I think I can say what maybe where do we go from here in the few seconds I have. I think we cannot also dismiss, I don't think it's been said in the conversation, that at least in the public, both Ogun State and the federal government of Nigeria have said they have attempted to settle this dispute, post their award, right? They've been on the table, negotiated, and it seems that all was going well until suddenly it wasn't any longer. I think, to be realistic, they can still pursue that avenue. It does seem that both parties can attempt to reach an agreement. So that's it as far as this big one is concerned. But going forward, I do think we have to be serious. Many states across the world are refusing to go with ISDS. ISDS is problematic. It is not academic point. We are seeing the effect it's having on us, both through PNID, and this particular dispute, even though the amount is not as much. There might be other issues that are concerned around corruption and so on and so forth. But the reality is that the economic space, that the damages that governments often get out of arbitral awards often puts them in much more dire positions than they were. In fact, think about the cost of actually litigating this dispute. Nigeria has been to the UK, US, France, Canada. They were in Quebec. So okay. This thing is not in one place. So we need to put our heads together and push against ISDS in its current form, not against arbitration, generally speaking.
Okay. Dr. Adeoye, your last words. Where do we go from here? Is Dr. Adeoye still there with us? Okay.
Yes, please. My advice is that professionals should do their job at all times, and politicians should make sure every of their action they consult with professionals. And once you do that, all this embarrassment will not be in place. Whether it's ISTS, whether it's the BIT, it's important to ensure credible, intelligent, experienced professionals in international law, international business are involved in every agreement. And where there is breach, I think we are better off if we deploy diplomacy to solving our problem before we cancel contract and then all this embarrassment is coming our way.
Okay. Prof, where do we go from here? And if you can answer that question of who pays that money.
Well, who pays the money? We have to pay the money eventually, but we can negotiate our way. On the part of the Chinese, I think they already demonstrated a big goodwill yesterday when they released one of the 3 aircraft. That's what I was talking about. That you can be pursuing, arbitration and at the same time be doing diplomacy at the same time. So that can go on. So eventually, I think they can come together and negotiate. We can negotiate our way up. But for me, what is important? Where do we go from here, Ayo? We need, as a country, to take our international obligations very, very seriously. Especially when it comes to investment. We cannot, on the one hand, be encouraging investors to come to our country with their hard-earned money and then, start giving symptoms out that, that we are not taking certain things seriously. We need to just up our game.
Yeah.
We need to inspire confidence in the international community that is coming to invest in our country.
Absolutely. Thank you so much for your comments. Professor Demola Abbas is Professor of International Law. He's also former Special Advisor to the Lagos State Governor on Overseas Affairs and Investment. We've also had Dr. Olabisi Akinkugbe, who is an associate professor. He's Purdy Crawford Chair in Business Law, Dalhousie University, Canada, as well as founding editor, afronomicslaw.org. Thank you so much. As well as Dr. Ogbenga Adeoye, a lawyer and chartered accountant, also an international business law specialist. Thank you for your time, gentlemen.
Thank you.
And now we know, where do we go from here? Well, where we go from here is take a break. When we return, we have another conversation. Do stay with us.